Hello and welcome. I'm Amritanshu Rai and you're watching Constitutionally Yours on Raj Sabha TV from this beautiful Gauhati High Court Old Campus building. In this program, we make an attempt to demystify the provisions of the Constitution. Today, we will take up issues relating to Assam. Joining me in this endeavor are a distinguished panel of guests. I have with me Justice B.K. Sharma, retired Judge of the Gauhati High Court, nominated by the Chief Justice of the Gauhati High Court. I have with me Mr. Siddhartha Bhattacharya. He is member Legislative Assembly. Assam has been nominated by the Speaker of the Legislative Assembly. And I also have with me Mr. Sherman. He is member of Legislative Assembly. Assam has been nominated by the Leader of Opposition, Assam. Joining us in the audience are bright set of students from National Law University and Judicial Academy. Let's start off immediately. It was in pursuance of the Assam Accord that Section 6A was inserted in the Citizenship Act in 1985, making the baseline of citizenship as 1971. But Article 6 elaborates or says a different story. It completely places the baseline for purposes of citizenship for the whole country to be something else, and that is 19th July 1948. Why two provisions on citizenship? Why is Assam being given this special privilege of having citizenship from a different date altogether? My question to you, sir, is straight away, is it justified to have a separate benchmark, baseline for citizenship in Assam and have a different baseline date for citizenship for the whole of the country?
If I have 2 minutes to speak.
Please.
Entry 17 in the Union list speaks clearly about acquisition and termination of citizenship. And Article 11 of the Constitution has given unfettered power to make any laws for any part or whole of the country regarding acquisition or termination of citizenship. So by making a different provision or by amending the Citizenship Act by incorporating Section 6A, I think Government of India or the Parliament has done whatever is within its domain. And regarding why this 6A has been incorporated only for Assam and not for the other parts of the country, we have to go back to history. Although India was liberated or the subcontinent was partitioned in 1947, but after 47, even after 1948, there was unabated communal violence and riots, especially during the 1950s. As per official record alone, around 1 million 10 lakh people crossed the border from both the countries. As per Assam Gazette, 52,600 families amounting to 1 lakh people, Muslim people, migrated from Assam to East Bengal during the 50s. So consequent upon this unabated violence or communal riots and cross migration of lakhs of people, Nehru-Liaquat Pact has come into being, which made provision for so that the people going into the other side of the border could come back, or the people coming into this side can go back. So this Nehru-Liaquat Pact came into being, and thereafter this Bangladesh war started in the late 60s, and ultimately Bangladesh was liberated on 26th March 1971, and consequent upon that, India was a party. India fought a proxy war for liberation of Bangladesh. We should not forget all this thing. And during that, after Bangladesh liberated on 26 March 1971, India entered into an agreement of peace and friendship with Bangladesh. So when this Assam agitation culminated in 1985 with the signing of accord. While signing this accord, Government of India has to take into account all those historical events, the Nehru-Liaquat Pact, the cross-migration of lakhs of people during 1950s, then the Bangladesh War, and the friendship, peace and friendship treaty with Bangladesh.
So what you're trying to essentially say is that the historical perspective is more relevant relating to 6A than anything else. The situation there, which is not there anymore, but the situation can't be overlooked.
Yes,
Correct, sir?
yes, and I would, Government of India is constitutionally bound under Article 51 to honor any law, any agreements or treaty or any
You're talking of
convention.
the Assam Accord.
Yeah.
You are talking of the
No,
Assam
while
Accord.
while signing the Assam Accord, Government of India has to take into consideration all those agreements.
Right.
Or peace treaty.
I'll talk. Mr. Bhattacharya, the question is, you've understood one side of the explanation. It's historical. But the courts which have taken this issue on board, the Supreme Court, the highest court, and the Constitution Bench, which has now started activity on it, if there was no constitutional contradiction, the matter would not have been accepted by the Supreme Court in first. I mean, that's the real thing. It has been accepted. Notices have been issued. In view of this, and in view of Assam Accord, in view of the historical perspective, is it possible for Assam to have a completely different set of parameters for citizenship and ignore the provisions for the rest of the country?
As has been explained by Mr. Hussain Ahmed, the historical perspective demanded that there be a provision in the constitution for citizenship in Assam, which may be slightly different from what is provided in the general laws. We cannot forget the historical background which has led to this situation. Assam has been witnessing unabated migration from Bangladesh, which was earlier East Pakistan. And most of this migration has been for two reasons. One is economic, people looking for better economic prospect in Assam. In Assam, population was much less earlier. There was lots of land, and other economic prospects were better than what was in East Pakistan. Then there was another perspective, that was people had to migrate because of persecution in that then East Pakistan and subsequently Bangladesh. So we have to keep these two aspects in mind. And as has been explained by Mr. Ahmed, he is very correct factually, that Constitution has provision where a specific or a area specific clause can be included for any of like measures that need to be incorporated.
But sir, it's a constitutional contradiction.
I will not say it's a constitutional contradiction, because in Constitution itself, as has been very elaborately explained by Ahmed, I will not go into that. Constitution leaves enough leeway to the
executive,
not executive, to the legislature to promulgate any act or incorporate any provision so as to mitigate any special occasion that arises in any particular part of India. So in that perspective, I feel 6A was a necessary provision which needs to be incorporated so that the special issues that has dominated the Assamese infiltration issues and all these issues
can be taken care of.
That can be taken care of.
Sir, you would like to, so various point of views you've got here. Infiltration is something that has been happening since 1935, right? And the first time it was acknowledged was when in 1945, the first time the Foreigners Act sort of thing came in.
That was in 1946.
1946 came into being, way before India got its independence. And then there were several other policy frameworks that were put into the system to prevent infiltration. Okay? As history progressed, and with all the issues that history has churned up, we are now at a position where a petition is there in the Supreme Court, and there is constitutional parity being sought. That why only Assam? Why not the other states? And if it is allowed, then why can't the other states also retrospectively go in for similar provisions? So what's the point of having Article 6 in the Constitution?
So
Yes,
the moot question is whether for Assam alone there should be a different parameter for determination of Indian citizenship. As we all know, 19th of July 1948 is the cutoff date for entire country. Why 19th of July 1948? Because there was huge migration from Pakistan immediately after independence, which India attained on 15th of August 1947. To curb the menace of illegal migration to India, an expulsion order was promulgated on 19th of July 1948. So that is the base here. So the Constitution provides under Article 5, 6, 7, 8, and 11. These are the provisions relating to Indian citizenship. It provides that the domicile in India, they will get Indian citizenship. Those who have migrated before 19th of July 1947 and those who have migrated after 19th of July 1947, but before the adoption of the Constitution on 26th of January 1950, they will be regarded as citizens of India. Now the question is whether on the basis of an accord, whether on the basis of the amendment to the Citizenship Act 1955, incorporating a provision like Section 6A, providing altogether a different criteria for Assam, is unconstitutional or not. The issue has been referred to the Constitution bench, 5 judges Constitution bench, by an order of 17 December 2014 by a division bench, formulating certain points. The points are whether this is violative of Article 14. As you all know, Article 14 provides for right to equality, whether this has been violated, whether there has been violation of Article 21, whether there is violation of the franchise right, because only the legitimate voters can vote, whether the deemed citizenship can be conferred to illegal migrants who have migrated into Assam, and why Assam alone? Why this distinction is made for Assam alone? Rest of the country it is 19th of July 1948, but for Assam alone, why 25th of March 1971 and preceding 25th of March 1971, 66 to 71, another stream has been created. They will not get the voting right for a period of 10 years, but after that they will get all the rights. Now whether the Assam can burden these illegal migrants, one thing I like to highlight. In 2004 in the parliament, when a question was put, the number of illegal migrants who have migrated to India, the number said to be by the Home Minister in the floor of the parliament, 1 crore 20 lakhs, out of which 50 lakhs alone in Assam. Now, in that particular order of 17 December 2014, by which the matter has been referred to the lesser bench, the first line quoted is, a prophet without dignity in his own country. And if you replace the word prophet to citizen, the citizen without any dignity in his own country. And in Sarvananda Sonowal 2005,
Yes, sir.
you all know, it has been said that the Assam is facing external aggression and internal disturbance. And the local indigenous people are being reduced to a minority community like that of Tripura. So all these things will have to be borne in mind. And if I am to give my own opinion, I will say Section 6A is unconstitutional.
Right, sir. Now we'll toss the question.
Last few reports of the Election Commission has shown that there has been a huge rise in the population of the Muslims, of the alleged immigrant Muslims. So in this context, don't you think that 6A has failed the purpose for which it was enacted?
I don't think that Section 6A has lost its relevance. As we have been talking, 6A has been incorporated in the Citizenship Act because of a special accord that was concluded between Union of India because of the Assam Accord. Let's go shorten up to that. Now, why did Assam Accord came up? As you have very correctly said, that there has been migration to Assam after independence. Prior to independence, as Justice Sharma has very correctly said, prior to independence, prior to the cut-off date, we have no issues on that. But after that, there have been two kinds of migrations, as I have said. One is for better economic prospects, and the other is for reasons of persecution in that and East Pakistan and now Bangladesh. Now, why I am distinguishing these two? It's because there are provisions, there are ample number of provisions in Indian laws, in Indian Constitution itself, in Indian Citizenship Act, where it has been categorically stated that if people face prosecution, immigrants expulsion from Assam Act 1951, that categorically says in the proviso that if there is any persecution in Bangladesh, then East Pakistan, then those persons will be given some shelter in India. And this has been one promise that was given to the minorities, because when India was partitioned, it was partitioned on the basis of religion. So Hindus or other communities like Buddhists, there are substantial number of Buddhists in Dardan, East Pakistan, and then there were other communities also. These communities, when their leaders met the national leaders in India and said that because of the division, we will be minorities facing persecution in a state which proclaims itself to be an Islamic state. So then the promise was given to these people that if you face any kind of persecution anywhere in that country, then we will give you protection, you will be welcome to India, and we will give you all the rights of a citizen. That was a promise. If you go to the Nehru Library in Delhi, there are ample number of documents.
No, sir. This government has also brought in a bill in the parliament.
Correct.
To granting them protection, specific people that you're talking of. So there is already a bill pending in the parliament.
Very true.
It's a constitutional...
now, the question that has been raised by him, I had to give a historical perspective, because this issue is very emotive, and this issue has also to be understood in a historical perspective. If we merely go by technicalities, then I think this issue will never get solved. It has to be looked into in a broader perspective, and that's why I feel 6A has not lost its relevance, as you have asked me. And anyway, this matter is before the Supreme Court, as has been pointed out by Justice Sharma.
I will get Mr. Sherman Ali in. Yes. He's got so it's very clear, because the bill clearly promises that entities who are either Hindus, Sikhs, Jains, Buddhists, and other than Muslims, they are the ones who, if they are prosecuted in Bangladesh, will find shelter. Sir's point is that it is 6A is relevant because it should not send back the ones who have come here for protection for on the reason of being prosecuted. Correct?
Correct.
Now, the point is, specifically, it is a target that the minority community in this country, the infiltration by the Muslims, that is what needs, that is what is creating the problem in Assam. And that is what you need to answer, sir.
You see, Government of India is bound to honor the international treaties or conventions, and by Article 51. Article 51 of the Constitution says that state shall endeavor to promote international peace and security, maintain just and honorable relations between nations, foster respect for international law and treaty obligations. This is constitutional obligation of our country. And this Nehru-Liaquat Pact, it was signed on 8th April 1950. Here the background has been given. The communal disturbances during the 1950s was mainly in Assam, East Bengal, West Bengal, and Tripura. And mostly it was confined to Assam, East Bengal, and West Bengal. And since there was agitation in Assam for long 6 years for deportation of migrants from Assam to other countries, so government of India has to come to an agreement with the All Assam Students Union and other agitating parties and sign an agreement. While signing this agreement, government of India could not forget those obligations and treaties.
Correct, correct.
So since it was, the agitation was in Assam, it was not in West Bengal, it was not in Tripura.
The special provision.
Yeah. This special provision has been made related to Assam, and government of India has every power, has unfettered power under Article 11 to make laws for any part or whole of the country regarding citizenship.
But
that
it
is one
can't
part.
be in violation of fundamental rights.
may-
We'll take
no,
a
no,
break. We'll come back. We'll come back to the same point.
Infiltration
We'll come
point
back to
also.
yes, sir. We'll come back to the same point. It's time for us to head into a break, a short break, and we'll be back on the same point. We'll continue our discussion. Welcome back. Continuing with our discussion. Yes, the point you were making, sir.
Actually, regarding infiltration, a large-scale infiltration of Muslims, I will be coming into the other part later on, religious persecution in the East Bengal or Bangladesh. Regarding infiltration of Muslims, large-scale infiltration of Muslims under independence, the agitation took place for 6 years, and after the Assam Accord was signed, and as per the Assam Accord, voter list was revised 4 times, extensive revision to detect and deport the foreigners in 1985, in 1989, 1993, and finally in 1997. On the direction of the Election Commission, the voter list was intensively revised, and at the end of each revision, intensive revision, it was first under AJP government, then in 89. After each intensive revision, the government of it could be detected only 2 lakhs or 3 lakhs of people. So this is the outcome of the 4 intensive. There were demands in different periods of time and again. And after intensive revision, what has been found that 2 lakhs to 3 lakhs people were left out of the voter list.
Yes,
they were
yes.
suspected.
Yes.
And the cases are going on in the high courts, in the tribunals, and the outcome of these cases is, during all these years, as per record available in the assembly, as per the reply given in December 2015, it was said that out of 100 cases tried in the court, out of the 100 cases for which the judgment has been pronounced by the courts, only 6% were declared as foreigners.
So what you're trying to, the point you're trying to make is the process has just identified 6 people only.
We're talking about the illegal immigrants coming to Assam. Now, why it was felt necessary to have the Expulsion Act, expulsion from Assam, Immigrants Expulsion from Assam Act 1950. The object and reason for promulgation of that act is huge number of illegal migrants have come to Assam. So an act is required to deal with the situation so that Assam is not ruined by the infiltrators.
Correct.
In 1950 itself,
It was recognized.
And that the Supreme Court in Sarvananda Sonal has said that irrespective of application of Foreigners Act 1946, this Expulsion Act 1950 will also hold effect.
Prevail.
Will also hold effect. And
Next
there is
question.
also a proviso granting protection to the Hindu, Muslim, Hindu, Buddhist, Sikh, Jain minorities who have come to Assam because of religious persecution. That law is already there.
Right. Question.
One more
Next
point.
question.
How can it be justified that under Section 6 of the Citizenship Act, the date for rest of the country has been set something else, whereas under Section 6A, the date is 25 March 1971. So I would like to ask, how is it not violative of Article 14 and 15 of the Constitution?
The background fact you all know, Assam Accord was signed. Pursuant to that, the amendment was brought to the Citizenship Act. Section 6A was inserted. So that is why the Supreme Court, by its order on 17th of December 2014, on number of writ petitions headed by Assam Sanmilita Mahasangha, has referred the issue to the constitution bench as to whether there can be disparity in the matter of granting of citizenship only for Assam. And for your knowledge, in Assam, Mr. Ahmed has referred to that only 6% foreigners have been detected. Nowhere in the country the foreigners are identified through foreigners tribunal, through a procedure of court. It is only in Assam. In rest of the country, it is by executive action. A notice is given, you are a foreigner, he gives his reply, then order is passed. But here, evidence is to be laid. Thereafter, he will file a writ petition in the High Court. Thereafter, writ appeal. Thereafter, he will go to Supreme Court. So how you tackle this kind of a situation when Parliament itself has recognized the fact that there are huge number of foreigners, and I need not tell anything by simply referring to the Sarvananda Sonowal case. You must have read it, 2005 and 2007. There you itself you will find there is huge influx to the state of Assam, and there is disparity in the percentage of population, and Muslim population has grown to the utmost.
Sir, do you think Section 6A of the Citizenship Act 1955 is protecting and promoting the illegal immigrants from Bangladesh, as Clause 3 and Clause 5 of the said provision is not time-bound and an ongoing provision?
The Constitution, if you go through the Articles 5 to 11, provide for the citizenship, the cut-off date, 17th of July 1948. True. Now for Assam, by inserting 6A on the basis of an Assam Accord, whether that can dilute the constitutional provisions, whether a different set of, altogether different set of citizenship provisions should be there in Assam. That's the question.
Yes, Sherman. Yes, quickly, sir.
I would cite one example in reply to whatever Justice Sharma sir has said. One Mainul Mullah in Assam, in Sangha constituency, he was declared as a foreigner by the tribunal. Ultimately, he was also declared by the High Court, and he went to Supreme Court. The pathetic part of the incident is that, history is that, father of Mainul Mullah was declared by the tribunal as an Indian citizen. Mother of Mainul Mullah was declared as an Indian citizen In spite of his both parents being declared an Indian citizen, both tribunal and High Court declared Mainul Mullah as a foreigner, and ultimately he had to go to Supreme Court to get justice. He was declared by Supreme Court as an Indian citizen. These things are also happening. We should not forget.
Okay, that's all we have time for in this episode. We will come back with a new issue and a new episode. Keep watching Raj Sabha TV.